All right, let's say we have an adult child who's helping an elderly parent, and the elderly parent is planning on moving in with the adult child. And the elderly parent lived in, let's call it County A, adult child lived in County B, all within the same state but different counties. And the elderly parent had a will, and that will was filed with County A. And the will was done at a time when that parent was going to be moving in with the adult child, and it was known that that was the intention and that was going to occur. Was it right that the will was filed in County A's surrogate's court? I would say no. The intention was that the parent was going to move. And the parent had the ability in their own mind to intentionally make this move. In other words, we were not relying on a power of attorney or a guardian establishing essentially a new domicile, a new place where that person would be living. It was the parent who intentionally decided to move to a different county. So why would that will then be filed in County A, even if there is an asset or assets in County A? And I'm bringing this up because it's a nuance that I would be thinking about in regard to helping a client with a will and what should be done with that will as far as keeping it safe. And I would say in this kind of circumstance, it should not have been filed in County A's surrogate's court because when the parent passes and the parent passes living in County B, the death certificate is going to show County B as where that person resided and was their domicile, where they intended to always stay and remain. And now it affects probate. What court will accept a probate petition? County A or County B? And in this case, it should be County B. And there is a lot of, factors that can affect this. But I'm bringing this up because some people will take action and maybe not really think through how this can affect things into the future. So one of those instances where I'm hoping people can slow down a bit and not just do something because it sounds good, but really think about, well, what does this mean into the future? How will this affect the future and what needs to be done? Now, let's take another instance where adult child is helping an elderly parent move to a different state. Well, of course, we have the same concerns about a will, legal documents. We need to review that. But crucially, I also want you to think about assets because we do not want to have two probate proceedings and deal with two different states in regard to having the will be determined valid in the domicile state and then do what's called an ancillary probate proceeding in the second state. And again, if you can go back to what are the intentions of mom or dad, do they have the ability on their own to establish that they are moving intentionally from state A to state B, or was there a power of attorney or guardianship in place where somebody else acting on their behalf based on the documents or the powers that they do have to move mom or dad in a way that establishes a new domicile? And looking at the assets and how we can plan better for the future, because I can tell you, even just one simple, in quotes, bank account can be so affected by the planning that is done or not done. And so if we step back and we say, well, what are we doing with all of this? This is information that I don't know what to do with. What I want you to just to take away from this is that we can say something is simple and great. We've done something that seems so simple, but in reality, how is that playing out? How is it playing out with what you know right now, the facts right now? And with adult children helping elderly parents, there's a set of circumstances that are so nuanced. You have to really get into, well, what are you planning? What does the next month look like? What does the next 6 months look like? What does the next year look like? And then really start planning. And I know it's a tough time because typically there is so much going on. And so that's why I always say to people, the more that you can establish some baseline as far as what documents there are, what people there are, what assets there are, and move from there, you're going to be so much better off. But if all of a sudden things have to be dealt with in quick fashion, that's where, generally people aren't able to think straight, let alone make good decisions. So I'm bringing this up because I've seen instances where I wish I could go back in time and kind of fix things, tweak things, or majorly change things for people because the way things unfolded just, wasn't good. And I hate to see that. So estate planning is more than just, getting a document done and thinking that everything's simple into the future. It's more about what are the factors, what do we need to assess, and how can we better plan accordingly. So this is Ruth George with Ruth P. George Law, PLLC, Trust and Estate Attorney. This video, as with any video I do put out, is for educational purposes only. It does not establish an attorney-client relationship, and I look forward to seeing you on another video.